Hello and welcome to the Immigration Bulletin. My name is Gus Shehab. I'm an immigration lawyer. Today I want to talk to you about the impact of divorce and separation on the removal of your conditional green card and how to do it. If you received your green card because you married a U.S. citizen, and if your green card was issued within 2 years of your marriage, you were given a 2-year conditional green card. But if you received your green card after 2 years of your marriage, your green card should be valid for 10 years. Make sure to check this important point because the USCIS, the Immigration Office, does make mistakes. If you feel your green card was issued by mistake for less than 10 years, you must go back to the U.S. Immigration to correct this mistake. As to the timing to file the petition to remove your conditions, you must file Form I-751 within the 90 days prior to the expiration of your green card. That means anytime, any day within those 90 days before the expiration of your green card, the U.S. Immigration must receive your I-751 form, the filing fees, and supporting documentation. After that, you will receive a receipt notice from the USCIS acknowledging that you filed your petition and extending your green card for 24 months. With that document, you can continue to work, travel, and resume your life normally as if you still have your green card. When filing the petition to remove the conditions, you can either file it jointly with your spouse or alone by yourself seeking a waiver. Now, there are only 4 ways that you can file a waiver, meaning that you sign the petition by yourself without your spouse. The first one is that your marriage has already been terminated. The second one is that you, the conditional resident, or your child was abused by the U.S. citizen spouse during the marriage. The third one is that the U.S. citizen spouse has already deceased. They died. They can't file jointly with you. And the final one is that the termination of your green card will result in extreme hardship to you. The first variation is that marriage has already been terminated, so through divorce or dissolution. Okay? So if the divorce or dissolution occurred prior to the expiration of the green card, prior to the second anniversary of your conditional residence, then you must proceed to file your waiver application by yourself. If the marriage termination occurred after you've already filed a joint petition with your spouse, so you and your spouse within the 90 days prior to the second anniversary of your conditional residence filed a joint petition, but subsequently, when the petition was sent to the immigration and it's being reviewed, subsequently the marriage is terminated. Okay, so what do you do now? What you must do is you must convert your case to a waiver. This is very important. Some of my clients call me up and they say, well, I heard that a lot of these petitions are approved without an interview, and I just don't want to do anything. I want to, proceed. This is very dangerous because if you don't amend your petition to a waiver, at the time of the U.S. citizenship application, you must then list when your marriage was terminated. And if the USCIS realizes, and they will realize, that your petition to remove the condition was based on a joint petition and you later divorced and did not amend your petition, they could rescind your green card because it was approved in error. So be careful. If the termination of the marriage occurred after the joint petition was filed, during the time that the petition is being reviewed, you must amend your petition requesting a waiver. The second variation is that you and your spouse, your U.S. citizen spouse, filed a joint petition, but subsequently you separated and contemplating divorce, and now you're called for an interview. Okay, so the joint petition is filed, you're called for an interview, but there's divorce proceedings that are still pending in courts. So if you're lucky enough to have the divorce or dissolution done and finalized before the interview, you can take to the interview the final court decree of divorce or dissolution and request a waiver at the time of the interview verbally. You can do it verbally to the officer. And take with you also additional documentation to prove that you entered the marriage in good faith. Okay, so if the marriage is terminated before the interview, you can request a waiver at the time of the interview, submitting additional evidence. However, if the divorce or dissolution, the marriage termination, is not finalized by the time of the interview, you must go to the interview and explain to the officer what's going on. The immigration officer will issue something called a request for evidence, and they will give you 87 days to terminate the marriage. The officer will also review the additional documentation in support that your marriage was entered in good faith. Now, after the interview, if you're able to terminate your marriage within 87 days, you can just submit a copy of the final decree of the marriage termination, and the case has already been now converted to a waiver, and the officer will make a final decision. If you're unable to terminate your marriage, and that's why I tell my clients, if there's separation or divorce, do it as early as possible so you don't end up with the situation. And the situation is that you went to the interview, your marriage, your divorce is pending. It's not finished within 87 days after the interview, because some jurisdictions require separation for 6 months, some require more. So if that's not done, the officer has no choice, by the way, right? Is 87 days have passed, you have not submitted the marriage termination court documentation, the officer has no choice but to place you in removal proceedings. The officer will place you in removal proceedings, will terminate your green card. It's not the end of the world. I've had many, many, many cases like that. Okay, so what that means is that your file is now sent to the judge. Your green card has already been terminated. Now, this is a big deal because that will affect your employment, affect a whole bunch of things. But what you can do is immediately you can file a petition to remove the condition requesting a waiver once your marriage is terminated finally, okay? And that will restore your green card. You will restore your green card status one more time, and the judge will give you time to have another interview with the immigration office to review your case and make sure that you entered the marriage in good faith. And if the officer is satisfied that has happened, then the officer will approve your petition and your removal case will be terminated. In other words, the judge will basically throw out your deportation or removal proceedings. Okay? So let's review that one more time. Right? If after you went to the interview, you told the officer that your marriage is being terminated, the officer gave you 87 days to do that, you're unable to do it within 87 days, the officer will have no choice by law but to terminate your green card and refer your file to the immigration judge to make a decision. Once your marriage is terminated after that, you can file a petition to remove your conditions, seeking a waiver. You'll be interviewed. The judge will give you time to be interviewed again with the U.S. Immigration Office. If the immigration is satisfied that you entered the marriage in good faith, they will approve your Form I-751 and your removal proceedings will be terminated. Okay? The final variation is that you and your U.S. citizen spouse have separated, but no divorce proceedings have started. You're just living separate and apart from each other. So if the separation occurred during the first 2 years, in other words, before the termination of your initial conditional green card, right, within the first 2 years, then you should file jointly. Even though you're separated, the law allows you to file jointly with your spouse, but you have to indicate clearly on the petition that you're living separately. In other words, the address of your spouse is different than your address. Then, once you file that jointly, your conditional permanent residence will continue. You'll receive a receipt notice extending your green card for 2 years. Then you must actively seek divorce so that your marriage is terminated before the interview. You'll be interviewed for sure. Once the USCIS realizes that you and your spouse are not living together, they will call you for an interview. And by that point, you will have your marriage terminated and you can convert your petition to a waiver. If your spouse is unwilling to file the petition jointly with you, your marriage is not terminated, your green card, your conditional green card is coming to an end, the only other choice that you can do is to file a waiver seeking or arguing that termination of your green card will cause you severe hardship, extreme hardship. That's the only way, because as we said earlier, there's only 4 ways that you can file a waiver. Marriage is terminated, you or your child have been abused during the marriage by the U.S. citizen spouse, the U.S. citizen is deceased, or there's extreme hardship to you if your green card is terminated. So now, as we see, we don't have those the 3 ones that we just mentioned. The only one that's available to you is to argue that the termination of your green card will cause extreme hardship. So that's the only one that's available to you, and you should do that, because if you fail to file a waiver application, your green card will be terminated. But if you file the waiver requesting consideration that the termination of your green card will cause extreme hardship, your green card will be extended for 2 more years, and you can go ahead and seek divorce and later convert your case to a waiver based on the termination of marriage. Okay? If the separation occurred after the filing of the joint petition, okay, you've already filed a joint petition with your spouse and you separated, you must then seek divorce, as we discussed earlier, or dissolution of your marriage, and convert your case to a waiver, as we discussed. So with that, I'd like to conclude my presentation. I want to thank you for watching this video to the end. And if you thought it was useful, please don't forget to like, share, and also subscribe to my channel. Thank you, and we'll see you soon.